Greetings everyone. We warmly welcome you all to our today's Ask Me Anything session. I am Advocate Akriti Singh, Assistant Vice President at NRI Legal Services. So our today's topic is insights on types of deeds and its significance for NRIs. But this session is also very useful for our Indian residents. So before we begin, I would like to ask my colleague to introduce herself.
Hello everyone, this is Advocate Alicia Monga, Senior Legal Associate with NRI Legal Services.
So we will be answering all your queries today as much as we can, and don't worry if we miss on to any query, we will answer it subsequently through our online portals. So let's begin with this enlightening and informative session for today. So feel free to ask anything which piques your curiosity or interests you. We are here to welcome all your questions. So our today's topic is basically about types of deeds. When we talk about, for example, NRIs, non-resident Indians, they have immovable and movable assets in India. For example, land, houses, shops, so many other assets in India.
Exactly.
And it is very important to execute a certain type of deed which is useful for you and as per your wishes, and so that you do not have to face any sort of problem in the future. So we will tell you all the nuances with this topic. So basically, what helps you in executing a proper deed? Firstly, it ensures a proper ownership record. Secondly, future disputes are avoided. Thirdly, it has a validity, ensures a validity in the eyes of law. So whenever you are entering into a deed, it is also very important that you do not end up signing a document. You should also get it duly registered so that you can safeguard your rights in the property. Right, Alicia?
Yes, talking about registration. So one such client, I remember, he came to us with an unregistered sale deed. So we clearly told him that it is invalid in the eyes of law. So to avoid such circumstances, you should always hire an expert, in executing such deeds.
Absolutely, Alicia. And I think you all must have heard these terms like sale deed, release deed and gift deeds. So there are certain nuances and compliance attached to these deeds. And before I start discussing these types of deeds through our queries, I want you to share a certain breakup of components, what all should entail in a deed, and I think you should shed some light onto it.
For sure, I will do that. So basically a deed should contain, when I talk about deed, a sale deed, transfer deed, a gift deed, they should contain the names of the parties involved, such as the buyer, the seller, right, the purchaser, the grantor, guarantee in a gift deed, donor and a donee. So all such details should be there in the deed. Secondly, there should be the description of the property. By description, I mean number that the property is bearing, the measurements of the property, location of the property, right, and any such distinguishing features that the property has. Again, you remember that matter we had. So in that sale deed, certain incorrect khasra numbers were mentioned.
Yeah.
So the opposite party raised an objection. Subsequently, we even had to amend that pleadings, right, and it caused a lot of delay. So to avoid such delays and complications, you should always bear in mind that always hire an expert who can guide you, and you should mention the exact description of the property in the sale deed. And not to forget about the consideration. So when I say consideration, it actually means the monetary exchange, which entails in such deed, sale deed or transfer deed, etc. So they should also contain the amount exchanged, the medium of exchange. For example, it was done online, through check, through cash, etc. I think there are certain more components to deeds. Would you like to add some light? Would you like to add certain points?
I think, Alicia, you have covered the parties involved, consideration and the description of property.
Yes.
I think yes, terms and conditions.
Yeah.
When we talk about terms and conditions, you should note that everything such as rights and liabilities should be explicitly mentioned in a deed. For example, there is a builder-buyer agreement, and there is no clause pertaining to the handing over of possession of the property. So that timeline, that specific timeline is very crucial. So such clauses, whether it is a payment of rent, whether it is a monetary consideration, whether it is handing over of a possession, anything which is important for your property and your rights. So it's all such clauses basically secures your rights in the property, it safeguards you, right? So clauses are very important. And I think last one is signatures and seals. When you talk about signatures, your signature should be similar on each page. I think I would also like to quote one of our examples from our own clients where the signature on the deed were different on each page. So, and when that such document is challenged in the court of law, your document becomes really weak.
Exactly.
So your signature should be similar on each page. Secondly, when we talk about seals, for example, there is a stamp of a sub-registrar, or even witnesses, their signs, notary public, everything should be very precise so that there is no ambiguity or discrepancy in a document.
Exactly.
So I think that covers up all. No?
Yeah, and I can see a question pop up. So it says, "Hi, I am from USA and I want to sell my property situated in Delhi. Should I and the buyer is required to be present at the time of registration?"
I'll take up this question.
Yeah.
Thank you, Advocate Kashyap. Firstly, you must understand, when we are going to execute a sale deed, the buyer as well as the seller both needs to remain present before the concerned sub-registrar. It is very, very essential because the registrar will also ensure the authenticity of the document which is being executed. And for example, in cases of NRIs, you are unable to come to India. You can give us power of attorney. Our firm aids in such services and helps NRIs to execute a hassle-free process so that attorney holder can appear on behalf of the parties, that is buyer and seller, and can execute a deed. I think this is the most common type of deed which is used in India. So you should all be very aware of what all it contains. As we said, the consideration amount, the description of the property, everything. But specifically, the tax obligations. You should know what all implications are there. And in case of NRIs, when you are going to use the sale proceeds, basically you are going to repatriate such sale proceeds, you should always make sure that it is according to the RBI guidelines, that is Reserve Bank of India. And I think even when you enter into a sale deed, there should be a proper title check that who was the previous owner, right?
Exactly. You should get due diligence done for your property.
Yes, that is very important so that you can check on to the encumbrances, any lien, any mortgage on the property, any tax which is due, and so that you can comply with the local laws properly. So I think due diligence is very important.
Exactly.
Do you have any further questions?
I can see another question.
Just a second. We are just looking for a question. Yes, I can see here.
So another question is from Priyanka, which says, "Hello, I am from London. My cousin's father is very ill and aged and he wants to make a will. Is it compulsory to register a will?" Well, will is a very burning topic.
Yeah,
we keep on receiving so many queries related to will. So I would like to take up this question.
Sure.
So Priyanka, will, firstly I would like to define as to what a will is. Will is a legal document, in which one owner transfer, a will is a document in which a person, right, specifies as to after their death how their assets, their properties, movable, immovable, will be distributed. Right. So while executing a will, one should always ensure that they are, executing the will in accordance with the Indian laws, so as to prevent any future disputes among the surviving legal heirs.
Right.
And now coming on to your question, whether the will should be registered, although it is not mandatory, right?
Yeah.
But it is highly recommended that one should always get the will registered. In case the will is lost or misplaced,
yeah,
firstly you can procure a certified copy from the sub-registrar's office, and secondly if an unregistered will is challenged in the court of law, so tomorrow you never know that the opposite side can shred an unregistered will into pieces.
That's absolutely right.
Yeah. I can see another question which says, "Hi, I want to cancel the attorney I gave to my cousin in India as I am residing in USA. Okay. When does a general power of attorney get cancelled?"
So, Ms. Kamalji, basically, when a general power of attorney is cancelled, when a person, executant, principal, executes a revocation deed, there is a proper process to it. If you execute a revocation deed, you revoke all the powers you have given to a attorney holder. That's your cousin in your case. You can execute a revocation deed followed by a proper publication, a notice is sent to the attorney holder, and then a deed is registered in the office of concerned officer, and you can revoke that particular deed. But I think for all the viewers, I must share this information that either you can revoke a POA through that is power of attorney, through a proper process of revocation deed, or for example, in case the executant dies, the power of attorney gets automatically cancelled. But there are specific reasons and circumstances when you should genuinely revoke a power of attorney, when you no longer trust the person to act on your behalf. Secondly, if the circumstances are not favorable, for example, the attorney holder is not residing in that location, he has relocated, or even the purpose of the power of attorney has been met. If you have given an attorney for a sale purpose, sale has been completed, I think after that you should revoke the power of attorney.
Exactly.
There is no point to keep on using it, right?
Yes, absolutely. And I see another question which says, hi, my mother is 65 years old, NRI. She is unwell. She wishes to gift her house to me and not to my brother. Is it possible? Well, Mr. Sunil, first of all, thank you for your question. It is absolutely possible only if this house of your mother is self-acquired and not inherited or ancestral.
That's true.
Right? Because your brother has, birthright in the ancestral property. And for executing such, the house in your favor only by excluding your brother, your mother should execute a gift deed. So a gift deed is a document in which one owners transfers the property into the name of another owner, and this is usually done in the blood relations, out of love and affection and as a gesture of goodwill. And I believe you should also keep in mind that while executing a gift deed, certain amount of stamp duty is applicable, right? So you should not never skip that.
And I think so many people opt for gift deed, so that one can transfer their asset during their aliveness, because will creates a lot of hindrances in future.
Exactly.
So that's the most used deed.
Right. So we are actually receiving many questions during this session. So another question is, Namaste, I am based in UK and I want to rent out my showroom in India. Which document to prepare for my property? I think showroom, they are referring to commercial property.
Yes.
So yeah.
Yes, you are referring to a commercial property, and please understand, when you want to rent out your property, whether it is a commercial one, there is a proper document which is known as a lease deed. Lease deed has a proper duration and expiry. Along with that, you can mention all the details of duration, lease period, the rent amount, its enhancement year by year. So lease deed is a very important and it is very apt in your situation. You should enter into a lease deed where lessor and lessee, that is property owner and tenant, enter into this deed, so that can be subsequently registered, and in case you face any trouble in future, so you can use that registered deed to evict that tenant or to claim the recovery of your rent as well. So lease deed is very, very important in such cases. And I think again, for NRIs who are sitting abroad, they can use such deeds to generate rental income. But again, the tax obligations are also there, and any withholding in India should be, I think, considered while executing such deed. And once you are a genuine, I think, a taxpayer and properly executing such deed, this will end up into a very genuine transaction, and you won't face any problems in future.
Right. So I see another question which says, good evening and thank you for these sessions. My father owns a chunk of land in Bhuj, Gujarat. I am living in UK with him and he wants to get a release deed done. What are the steps? So can you tell them the steps to be done for the release deed?
First of all, thank you for liking our sessions. And when we talk about release deed, I think I'll just little bit reframe your question here. If you are one of the co-owner in the property or land, then you can execute a release deed. Your father can release that portion which belongs to him in favor of another party, whether it is you or your sibling, anybody. So if you are not one of the co-owners, then release deed cannot be done. Then he can execute a gift deed, I think. But release deed is something which is done between the co-owners, the existing co-owners, so that one share, one of the share can get transferred to the other party who is also current owner in the land. And I think they have also asked for the steps. When we talk about steps, you draft a release deed, obviously take expert advice, properly draft a release deed. Both the parties, releaser and the releasee, both the parties should remain present before the concerned officer again, or this process can also be executed through attorney holder. There will be proper witnesses, signatures, but I think this is a very basic steps which we are sharing. The most important part is when you get this release deed registered, subsequently you should get the records of revenue updated. That this release deed has been
most important.
Yes, it is very, very important, because without that you won't be considered as the current owner in the revenue department or municipal body wherever your property is situated. So the second step is more important.
Yes, correct. And we have another question up which says, "Hi everyone, I am going for a settlement for the properties involved. Is registration required?" I think she is referring to the properties of a family, right?
Okay, I think this is similar to a partition deed or family settlement deed. A settlement can be of a share in the land, or maybe the movable assets, or even FDRs lying in the accounts. It can be anything. So when we talk about such settlement deeds, if it is done amicably, it's very good.
Exactly.
All the parties should sit together and decide which share belongs to which party. For example, you have a house and you are entering into a partition deed amicably with your family. You can decide which floor will be given to which family member. Or if it is a chunk of land, then a north direction or a south direction.
Exactly.
You can divide that portion accordingly. But in case, I'll just add up, your family is not cooperating in such partition,
yes,
you can opt for a suit in the court of law, which is known as suit for partition, because your rights are very important and you can claim it in any way, through court or through amicable procedure.
Yes, definitely. If as my colleague said, that if the family is not ready for a settlement amicably, then you should approach the court of law.
Absolutely.
And the court will either auction your property, either sell it out, and then the sale, as the monies will be distributed among the parties, or it will partition the property, like the specific portions will be given to each party.
Yes.
So we have another question up. There's a lot of questions we are receiving in this session. So which says, "I want to give attorney to my uncle for sale of my land.
Okay.
Do we need to get it registered?" Right? Well, yes, Mr. Ashwini, if you are not physically present in the jurisdiction where you wish to sell your property, you can execute the power of attorney in your uncle's favor, right? However, please keep in mind that this document will give all the powers, right, and will authorize your uncle to act on your behalf in relation to the property matters. And should you get it registered? Well, yes, it is highly recommended that you should get the power of attorney registered, as well as my colleague just explained, you should also get it revoked once the assigned task of sales are completed, so as to further avoid any misuse or any discrepancy in the sale of such property.
Right.
So we have, I can see another question up which says, "My father's side of the family wants to divide their share on the property. Okay. Can you enlighten us about the partition deed?"
Yeah, as I just mentioned the previous question.
Yeah.
Partition deed, again, a document where you separate out the share of each party involved, and generally in such cases all are co-owners. Sometimes there are 20, 30, multiple owners, aunts, uncles, siblings, and you need your own share. And I think especially who all are sitting abroad, they want to separate out their share because they can transact that portion of property accordingly. They can sell it, they can rent it. So it is very important that once you have such joint huge properties, you should separate out your own share so that you can use it according to your wishes in future. So it is very, very essential. So as I mentioned, partition deed is again a very important document which should be properly executed, and then it becomes valid in the eyes of law, and you can use it in future to use it any manner, I think, as I said earlier.
Yes, exactly. As I can see, we have missed out a question in the past which says, "Can you tell us what are the steps to be taken after execution of all the deeds?"
Okay.
All right. When you say all the deeds, I will cover the main deeds like sale deed, transfer deed, gift deed, right?
I think it's a very good question.
Actually. So what are the steps? Basic steps, I would say, firstly is to get your deeds registered. As we already explained, right, in the beginning, that it is very important for you to get your transfer deed or sale deed registered with the concerned sub registrar's office, right? Because registrations, awares the public that this property has now been transferred from this person to this person.
Yes.
And also it establishes the rights of the new owner.
Right.
And after doing this, what you should do is you should immediately update the revenue records. Right, it is very important that the new owners name should be reflecting on in the revenue records, right? Such as you should update the Jamabandis, the Khotanis, and in Gujarat you should also, I think, do
There are
updation.
particular village forms.
Yes,
And a property cards.
exactly. So after that is done, as a third step, you should also consider the tax implications, right? So both the parties, the buyer as well as the seller, right, should keep in mind that there are certain tax implications imposed on such transaction, right? So you should consult your tax advisor and should ensure compliance with the tax laws. And as a last step of all the deeds, what you should do is you should maintain a legal documentation, right? That is the chain of the ownership, the record of the previous owners, right? The municipal tax received, electricity, water bills, and the agreement to sell, etc. The list goes on and on, right?
Yeah, absolutely.
So this is, just to for the future reference and to also mitigate any potential, future risk.
Yes.
So that you should do.
I think documents also vary from state to state.
Yeah.
So ownership documents are different.
Exactly. For the time being, I am not able to see any new question, but then we would like to enlighten the public about sale deed, right?
Yes,
Yeah,
yes,
we
you
will
should
do that.
So as I mentioned about sale deeds, most used document in our entire, I think, jurisdictions and all over India. So basically in sale deeds, as we said, compliance is very important. How you check your record, how due diligence is done, how title ownership documents are verified. You go to the concerned official, dig out the documents, which is a fairly simple process, and then you can ascertain who is the current owner to avoid any future disputes and you don't end up in a legal suit, right?
Exactly.
So is there any further questions?
Yeah, I can see another question. Hello, I wish to gift my daughter some amount of money.
Okay.
Shall I execute a gift deed, and what are the essentials of a gift deed? So as we just told you that yes, you can absolutely gift some amount of money to your daughter, right? You can execute a gift deed, and the essentials of the gift deed, as I told you, that the names of the parties must involve, the amount of the money that you are gifting your daughter to, right? The reason for such gift, which is obviously out of love and affection and as a goodwill gesture. Then the mode of payment, how you're gifting it through online mediums or through cash or check, so these are the basic essentials. And for more insight on it, you should definitely you can approach our legal firm and we can guide you further on.
And I think in gift deed,
Yeah.
specifically the stamp duties are involved.
Exactly.
Yes, in each state. So stamp duty affixation, in case of females it is lesser than men, but in each state there is a defined set of stamp duty applicable as per the value of the property or maybe the asset. For example, you are gifting a immovable property, then a stamp duty will be affixed.
Yes, and I think while we are on it, we are missing a very important deed that I would like to state here is a mortgage deed, right?
Yes.
So what is a mortgage deed? So mortgage deed is a deed in which the owner of the property pledges his property as security for a loan amount, right?
Yes.
And this type of deed basically contains the loan amount, right, the interest rate, the payment plan, right, and it also contains the rights and responsibilities of both the lender as well as the borrower, right? So I would again now cite here an example, right, that we face. So one of our client's brother, fraudulently got a mortgage deed signed from his brother who was an NRI, and just because he was not unable to understand the regional language, that is Punjabi.
Yes.
Right. So not only mortgage deed, whenever you are entering into any type of agreement or executing any deed, you should make sure that you are able to understand the regional language. And if not, it is very important that you first get it translated, right, and to the help of an expert, understand the contents of that deed and then only sign it.
Yes.
Right.
Knowing the language is also very important.
Exactly, yes. That's it for now. We'll cover sale deed, we've covered, right?
Yes, we have covered sale deed, mortgage deed. I think
The
most
gift
of the
deed.
questions are covered.
Yes. Will also we've covered. I'll just
Can
see
you
that
please
we are-
check and refresh if there are any further questions,
Yeah.
so that we can answer all of them before we wind up this session. I think we have one question here. I think we just refresh. It's actually good to know that we are getting so many questions back to back. So yes,
Yeah.
here you can check. It was
Yeah,
gift.
I think
we have covered up. So
Yeah,
we have
we've
covered up
answered it.
all the, I think, questions, and in case you have any further questions, you can definitely write us at query@nrilegalservices.com. And before I wind up this entire topic, let me tell you last few things, that whether it is buying, selling, leasing, anything, when you enter into a proper transaction, it ensures that you have done a very authentic deed which avoids any hassle in future, and such smooth transactions not only help you in future but safeguards your right in totality, right? So take advice from the experts, follow all the guidelines in whichever state you are, so that you do not end up into a dispute where such deeds are challenged. So it is very, very important, I think, and while understanding such deeds, I hope that this session was helpful for all the people, and we are here to help you, and we will be back with another Ask Me Anything session very soon. Thank you, viewers.
Yes, do comment, like and subscribe our channel for more such enlightening sessions.
Thank you.